Second case on this morning's docket. That is case number 111124, State of Kansas v. West.
Christina Curls of the Appellate Defender Office representing Mr. West. Request 2 minutes for rebuttal.
2 minutes is granted. Counsel, I see a group of students entering the courtroom. If you want to wait a while till they're seated,
Okay.
or you may proceed, it's your choice.
I'll go ahead and proceed.
Very well.
Just briefly, this is a restitution issue. Mr. West pled no contest to criminal damage to property, and at sentencing requested, based upon his financial situation, that the district court not impose the $5,212 in restitution.
Counsel, I have a couple questions about what was actually before the court that day.
Yes.
It was the regular sentencing, and the restitution issue just came up in the sentencing, is
Yes.
that right?
Yes.
Okay, and so did the court have, do we know from the record, did the court have the entire court file in front of it? Did it have, for example, his poverty affidavit in support of
I
appointment
do
of
not
counsel?
know if it had the entire court file in front of it. I do know that defense counsel did reference the poverty affidavit when indicating that Mr. West was on disability and only had $1,000.
The only statement actually made by your client that day was that he was on disability, right?
I believe so, yes.
Okay, and then there was whatever was in the poverty affidavit, if in fact that was in front of the court.
Yes.
And then there were the statements of counsel.
Yes.
That's the sum total of what the judge had to determine the question.
Yes.
Thank you.
And going to that information, the poverty affidavit did indicate that Mr. West was on disability. He received about, I think it was $1,085 per month on disability, and then he had a list of his expenses: $350 for rent or mortgage, whichever that was, $100 for food, $250 for utilities, which in and of itself totals $700. So of his $1,085 from disability, that's only $385 left. In this case, he was given probation, 12 months probation. Dividing the amount of restitution that was ordered over those 12 months, he would have to pay $434 a month in restitution, which he didn't have that left after he had to pay for his necessities like food, rent, and utilities based upon the information in the poverty affidavit that was a part of the court file. We would argue that this shows that the restitution plan, which was ordered by the district court, was unworkable.
Under the statute, does the defendant actually have to put on evidence that would be admissible under the rules of evidence in this situation?
I couldn't find anything specific that indicated that there had to be evidence such as what would be presented at a jury trial or something, which is, to go to the state's point in its original brief, they were arguing that there was no evidence presented in the statements of counsel wasn't enough, but to support that point, they relied upon Gannon v. State, and the part in that opinion that they relied upon was a section that pointed to jury instructions, a parentheses, which its citation was to jury instructions because at oral argument that the attorney admitted that statements made by counsel weren't evidence, but it was a completely different set of circumstances because the court for that instance was trying to determine if there was any evidence presented at a jury trial to find that plaintiffs had standing. This isn't that situation. This is a restitution hearing where the district court, where the defense counsel referenced a poverty affidavit that was a part of the court file that the defendant filled out under the penalty of perjury. And I couldn't find a restitution statute that specifically said that statements of counsel could be considered in determining restitution, but in other sentencing issues, statements of counsel can be considered. Specifically, 216815 D3 allows statements of counsel either written or oral, to be considered in determining whether or not there are mitigating factors. So I would argue that in and of itself, a sentencing proceeding is different than a jury trial. And the law that the state relied upon to say that statements of counsel are not evidence deals with jury trials, and this is a completely different proceeding. However, we'd also say that the poverty affidavit in and of itself that was a part of the court file, taken with the arguments regarding the information in there, would be sufficient for the district court to make the decision based upon the information that was in the poverty affidavit, and that he was only bringing in $1,085 a month, but his basic three necessities, rent, food, and utilities, equaled $700 a month. There's other payments for $575 a month, and I don't know what that refers to, but if that is other payments, other necessities, other court costs, whatever it may be that he has to pay, then obviously that takes up the entire amount.
We don't know anything from the record in this particular case about whether the disability your client suffers from is a permanent condition, or whether there's any ability to earn money aside from the disability payment. Other than the poverty affidavit actually indicates he has some very limited income, annual income.
It is not clear what kind of disability, given the facts of the case surrounding the underlying crime. I would imagine it's a mental disability.
He made a reference to some mental problems.
He did make a reference to some mental problems, and the criminal damage
that's
to
all
property
we don't
was
know.
right.
Okay.
I guess my argument to address what I think you're probably getting at is the restitution order as it was made by the district court is unworkable. I'm not arguing here that any restitution order would ever be unworkable, just that the restitution order as it was made, the $5,212 as it was made, taken in conjunction with the order of probation, which ordered him to pay $553 a month, minimum monthly payment, the bulk of that being from restitution, was unworkable as it was ordered.
And part of the equation that makes it unworkable under your argument is that it was 12 months was the time in which defendant had to pay. That was the length of probation.
That is a part of the reason that it would be unworkable, which was
That's what gives you your $435 a month. Is you just take the total amount divided by 12, don't you?
right. Which is why I'm saying that I'm not necessarily arguing that no restitution order would be unworkable if they had reduced the amount of restitution to make it something he could pay within 12 months. If they had reduced the monthly payments.
Or increased the length of probation.
Right, because I recognize that it can be increased, but the order of probation in this case ordered him to pay an amount that was just unreasonable for him to pay based upon his circumstances.
So what's the remedy you seek?
Best case scenario would be to vacate the restitution order, but I also think that it would be reasonable to remand for a new restitution hearing to determine what would be reasonable and for him, what would be a reasonable, workable restitution order based upon this financial assets that this defendant actually does have, and not even at the sentencing hearing, the state acknowledged that it was unlikely, or that there was a likelihood that the defendant would not be able to pay the restitution that was ordered in this case, but asked that it be awarded anyway because there's always a chance that he may come into some money and be able to pay it. We would argue that this vague chance that he might come into some money isn't enough to make the restitution order unworkable. Otherwise, no restitution order would ever be unworkable, because I guess there's always a chance that anybody may possibly come into some money.
Well, that raises my question, which you may not be able to answer. What does it mean? What does unworkable mean?
It's not really clear with any case law or the statute itself.
What do you think it means, or what propose a definition that this court could adopt if we agreed with you?
I think the most reasonable would be to tie it to reason. is that something that he could reasonably be expected to pay. If he's only getting $1,000 a month and 300 of the, or only has 300 left after he has necessities, then it obviously isn't reasonable for him to have a restitution order that would require him to pay $434 a month unless he wants to be in violation of his probation.
So you're asking us to tie the concept of workability to the policy goal of actually having the defendant pay off the restitution award, because I can think of another reason why victims would want restitution awards, and that's because they're reducible to a civil judgment effectively.
And that would, that's another reason why it was argued that this restitution order wasn't workable, because even if there was a civil judgment, they wouldn't be able to get anything from his disability.
Well, not right away, but that ties into the, again, to from a victim's perspective, the ability to collect on that at some future date at which the defendant may in fact have the necessary resources.
But then under that reasoning, if someone may somewhere down the road possibly have the resources, then no restitution
Right. Well, that's what I'm
claim
asking.
could ever be considered
Should that be part of the workability consideration?
I-
That's
I-
really my question.
I don't think so.
Okay.
Simply because under that scenario, then it could be very easy for district courts to say no restitution plan is ever going to be unworkable, because there's always a chance that someone could buy a lottery ticket and win $1 billion. But it's not likely. It's not probable.
Are you saying we take a snapshot on day of sentencing? Or
And likelihood of, I mean, you look at sentencing. I guess the best way to answer that question is to compare this case to the Goler case, where in that situation it was found that there was no abuse of discretion in failing to in ordering the restitution or in finding that and they didn't find that the restitution plan was unworkable because of what was actually said at the sentencing/restitution hearing. In that situation, the defense counsel was arguing for a downward dispositional departure, so talked about the defendant's ability to work, about the fact that he was unemployed now, but it was likely that he would be able to get a job and actually make money in order to support himself on probation. It was a reason given for granting probation, but when that was denied, the defense counsel argued, well, since he's going to be in prison or in prison, he can't work, so any restitution plan would be unworkable. We're not arguing that
which brings us back full circle to some of the questions that were asked early in your argument. What do we know about this circumstance? And if the defendant doesn't put on evidence to give the district judge an opportunity to look at what are those potentials, how can it be an abuse of discretion?
Well, we would argue that based upon the information that is in the sentencing hearing, there is enough. We have the poverty affidavit, which was referenced, that he's on disability.
But that's the snapshot of that day.
And-
or actually, it's a snapshot of what may have been several months ago when the case was filed. And
defense counsel also indicated that it had been long-term disability based upon we would argue that there was nothing to indicate that disability was going to be ending anytime soon, just based upon the fact that the defense counsel did indicate that it had been a long-term disability, and reading what Mr. West had to say at sentencing, while he didn't necessarily state that it was going to be a long-term disability, if you read what he said and the way it kind of, I'm trying to define something that's almost undefinable, because as I was reading it, it seemed fairly obvious to me that this defendant does still have some mental issues, that it's unlikely that he's going to be taken off of mental disability
So what you're trying to say
anytime
that
soon.
if someone's mental problems are enough to put them on disability assistance, they're probably of the permanent variety rather than the transient variety?
I would imagine yes.
Okay, I think that's what you're trying to get at.
Yes, that is what I'm trying to say, and get taken into account the fact that the underlying crime in this case was he ran in his car into a mental health facility.
I have one more question that has to do
Yes.
with the contours of any definition of unworkable. Should that also take into account whether any amount ordered would necessitate an eventual extension of the probation term?
I
Should
think,
we care about that, given that the legislature has said it can be extended indefinitely until they pay?
I think we should care about that, once again, within reason. I was doing a little bit of math on this because the Heron case that I talked about in my petition for review that was decided by the Court of Appeals after we wrote the briefs in this case, it found that apparently the state had recommended $10 a month in probation. But if they paid $10 a month in probation, he would be on probation for 57 years. I did the math in this case. If he was ordered to pay $10 a month in probation, Mr. West would be on probation for 43 years. I would argue that that is unreasonable. But doing the math, I just did to try to figure out in case I was asked what could be reasonable. For 5 years, he'd have to pay $86 a month. Based upon the $300 that he has left over at the end of the month, that could be reasonable. And I would argue that extending probation for 5 years to pay probation or to pay restitution could be something that could be reasonable.
But there's some point at which someone who's done a criminal damage to property that amounted to about $5,500 maybe shouldn't be subject to probation anymore? Is that what you're suggesting? How heretical?
Yes. Yeah. I mean, I can't really give you a bright line as to when I think it should be cut off, but I think common sense should probably play a role in it in determining, and it could be a case-by-case basis. If it's a $12,000 damage, then the amount monthly payment, it might be reasonable that that be extended longer than 5 years or longer than whether or not longer to make reasonable payments, or the workable probation or the workable restitution order may simply involve reducing the amount so that it can be paid within the amount of probation or within a reasonable amount of time on probation.
And I take it from your answer that you view the restitution workability to be limited to the question of paying the restitution and not at it looking at a broader picture of what might be some of the other rehabilitative or punitive effects of a restitution order, such as just getting the defendant's attention, that making them realize there is a real consequence because of your action.
Well, as
any of those types of things.
As there's case law that is, I can't give you a case off the top of my head, but I know I read it in one of the cases that's cited in the briefs that restitution isn't meant to be punitive. It's meant to make, yes, it's meant to compensate who was hurt by the crime, and it's not meant to be punitive. I think it would open a can of worms if we allow the workability analysis to take into account the punitive aspect of it, because then you'd have other potential issues that come into play when you're dealing with punishment as a part of your sentence. But I do think workability should deal with the defendant's ability to pay and whether or not it's something that can be paid by the defendant given his resources within a reasonable amount of time.
The frustration I have with all of this discussion is I'm trying to figure out at the threshold level, shouldn't the defendant come forward on the day of sentencing with the case for having restitution waived, or the case for having restitution modified, or whatever the terms need to be? Because it really seems like the defense counsel showing up at sentencing and saying, well, Your Honor, look at what's in the court file, and what's in the court file is he's getting disability. And then we want to infer from that if he's getting disability, well, it must be for something long term. Or, in other words, it seems like the first step in this process has got to be imposing on the defendant the burden to come forward with evidence, which is what Justice Byers started this whole thing with evidence that people can then talk about rationally without just having sort of the argument of counsel going back and forth and guessing about the inference. So, I mean, shouldn't we be saying, to get to my question, that the burden at sentencing is for the defendant to come forward with evidence that demonstrates whatever point they want to make about restitution?
I do agree that that would be the better practice. In relation to this case, I think it's our contention that what the defense counsel did, based upon the record in this case and based upon the file, was sufficient for the district court to recognize that the restitution that he ordered, and as he ordered it, was unworkable for this defendant. That he had the information based upon that poverty affidavit to know that this defendant wasn't going to be able to pay that amount of restitution within that amount of time.
But that gets you then to the date of the poverty affidavit, which could be several months before the sentencing proceeding. And you know, what if something had happened? I mean, it seems to me you have to come in at the day of sentencing and say, this poverty, you know, here's our evidence that says this poverty affidavit, that those circumstances have not changed. So this is the universe of our assets that we're talking about. And then put on evidence about he's getting disability, this is the type of disability that he's getting and why. And then that lets the state come in and argue whatever it's going to argue about why your evidence is good or bad. That doesn't seem unreasonable.
I would agree it doesn't seem unreasonable. It would be the better practice, but I wouldn't argue, I wouldn't necessarily agree that the laws that existed at the sentencing hearing necessarily imposed, it did impose a duty on or a burden on the defense to present, to show that a restitution plan was unworkable. Our argument would be that what was presented and what was argued at sentencing didn't meet that burden. But I do agree that the better practice would be to have more information, as it almost always is the better practice to have more information. But that doesn't necessarily mean that if that isn't followed, then it wasn't sufficient. And that would be our argument, that what the district court had before it at sentencing was sufficient for it to be able to clearly see that the restitution order that it imposed was unworkable for this defendant.
Refresh my recollection, does the statute say unless defendant proves the plan is unworkable, or does it say unless the court finds?
I would have to relook at the
Okay.
wording on
All
that.
right.
I'm not 100% sure which one it is. But unless there are further questions, I would ask this court to reverse the Court of Appeals and the district court's restitution order.
Thank you, counsel. Before we start with the council's opposing remarks, I'd like to announce that there was a group of students that entered the courtroom as counsel was beginning her argument. Could someone from that group please stand and identify who you are?
Yes, sir. We are with Bishop Seabury Academy in Lawrence, Kansas.
I'm sorry, from where?
Bishop Seabury Academy from Lawrence, Kansas.
In Lawrence. Very well.
Thank you very much.
Thank you for coming. Please proceed, counsel.
Thank you. Barry Disney for the state of Kansas, and just for the benefit of the audience, this is a case where the defendant ran his car into the building of a mental health service that he was a client of, causing $5,500 worth of damages. He was put on probation for 12 months, and the court ordered that he pay that $5,500 back as a condition of probation. His contention is that's unworkable, and so that's why we're here today.
That's a good summary. Thank you.
Thank you.
To start with, did the state, first, do you dispute that the poverty affidavit would have been admissible at the sentencing hearing, given that defendant was present? It wouldn't be hearsay. It was an affidavit, that it would be admissible evidence.
It was sworn to under oath, and I believe that the court could have relied on it.
And and it was referred to by defense counsel.
It was.
Did the prosecutor dispute the validity of the numbers in that affidavit?
Well, that's interesting, Justice, because if you look at the affidavit, it's on page 9, on page 10, volume 1. It says he has a $1,085 disability. And then, as counsel pointed out, sworn to under oath, if employed, what is your monthly average? $750. So if you
Is
add
that-
those
is that
together,
the-
that's
Excuse me,
$1,800.
counsel, is that the monthly average or the annual? I'm sorry, I misread that in the brief, I think.
Well, line 3, it says, if employed, what is your monthly
Monthly,
average?
okay, thank you.
So, if you look at the affidavit, he's making $1,800 a month.
If employed.
Well, if employed, what is your average? I mean, I think this is clear. He's saying I'm employed. This
Yeah,
is-
it's,
Now, so if they want to rely on the affidavit, then it's $1,800, and we shouldn't be talking about 1,000. Perhaps he was saying that's what my wife earns, and that our total household income is $1,800, but we don't know. But he does claim all the mortgage. He does claim all the utilities. So even if it's his wife's income, shouldn't there be some sort of evidence presented about, half, what's the mortgage payment, half the mortgage payment, how much should be attributable to him? And that's the real problem on this case.
And if you run those numbers, your numbers, the 1,800 plus or less the expenses, is there sufficient discretionary or net to pay off $5,212.46 in 12 months?
Yes, because his attorney said the necessities are $1,000 a month. So that's $750. And as the dissent points out, $635 a month would do it. But
Can I ask some specific questions about the order? My understanding is that the full restitution was ordered to be paid as a condition of probation. Is that correct?
say that one more time.
That the full restitution amount was ordered as a condition of probation.
Yes.
That wasn't broken down as a monthly requirement, was it? Or was it? Did the court's order say you shall pay whatever the amount divided by 12 is every month?
The court didn't say that, but when there was an order of probation that was entered, when the defendant meets with a probation officer
Right.
and they do it, and then I think at the bottom of that, it just did a division by 12 months.
Sure, and so that leads to my next question, which is, as a defendant in this circumstance is on probation and they make good efforts, what the probation officer determines to be good faith efforts to make payments towards restitution, it strikes me that it's certainly a possibility, at least, that at the end of that 12 months, the full amount may not be paid back, but what would happen is effectively the probation term would be extended.
Well,
Is
yeah,
it-
and that's, yes.
Is that a
What would
possibility in this case?
Sure, and it happens all the time. The probation officer meets with the client, and the client either agrees to an extension or a motion is brought before the district court. And I think that's really the answer in this case.
Well, let's
what-
talk about that. Go ahead.
Okay.
Sorry. So just my next question then is, does that factual scenario render a plan of restitution unworkable?
No, and because I don't see why, when you're looking at one unworkable, why you're always going to the original term of
Okay, so
probation.
then my final question, I'll turn you over to Justice Johnson, is
Sure.
respond then to the Court of Appeals opinion in Heron, which seems the defense counsel's referenced it. As I read that opinion, the majority appears to say that, look, extending that term of probation may in fact render it unworkable. Can you just respond to that argument?
Sure. I think that Justice Powell was correct that the Kansas legislature spoke on that. That's a policy decision when it says probation can be extended indefinitely.
So your position is just that the Court of Appeals majority in Heron is wrong,
Well, I think Justice Powell is correct.
and he wrote the dissenting opinion.
Yes, and so I think the opinion is wrong. But here, I do think that the solution is this. The defendant can object to the extension of probation. He can do it on year 1, year 2, year 3. And if we get to an unreasonable extension, then he can appeal that and come in and say, under the facts of this case, an extension of 5 years into the 5th year is unreasonable. You asked earlier, how does this court define unworkable? I mean, I think it has to be unworkable when the length of probation is so disproportionate. But you don't know that until you get to that point. So the defendant can extend probation or can object to an extension of probation when it gets to the point that he thinks is unreasonable.
But let's talk about that. You have two people. One is more affluent, one is in poverty.
Two defendants.
And the statute says the length of probation for this particular crime is 12 months.
Right.
And so you're saying that, and probation is a deprivation of liberty. You would agree with that? It's not being in jail, but it's a deprivation of liberty.
I mean, I suppose in a technical sense, really probation says don't violate the law. I mean, that's what probation is. But yeah, it's a restriction. I agree
And
with
so
you.
you're going to deprive the liberty of one person, the poor person, more than the rich person, simply because they don't have the money. We don't let people be put in debtor's prison. So why is it philosophically okay to punish the poor people with longer probation?
Well, quite frankly, our society, people with money can pay off their debts quicker. This is, I don't want to get too far away from the fact that this was an intentional act of the defendant to destroy someone's property. And
the legislature has made the determination for that intentional act that the length of probation is 12 months. Did it not?
And they've also said probation can be extended indefinitely for restitution.
But it can't be. You and I both know it can't be extended indefinitely because that would be a constitutional violation.
At some point it would be, and we also know in reality at some point, 2 years, 3 years, that it gets terminated and costs go to collections. So
Could his probation be revoked the third year into not satisfying the restitution obligation and incarcerated on the underlying crime?
I will say in 30 years of doing this, I've never
I know it hasn't
seen
happened. Maybe it hasn't happened in your experience, but isn't that a consequence of not satisfying conditions of probation?
Technically, conceivably, it could be. I think that the more realistic is for him failing to pay or even making a good faith effort to pay is what I've seen the violation for. But I do think that there was a question asked, what does the statute say? The statute says that the defendant has the responsibility to come forward. And I know that this case is probably before the Supreme Court to give some guidance to the lower courts on how to look at unworkability. But in this particular case, I think this court should tell the defense, look, you didn't present the evidence. What do you look? Do you analyze this as $1,800 a month or $1,000? Because the defense attorney, when he said $1,000, was just wrong. And it's not the state's fault. It's the defendant's fault for not coming forward to evidence and fleshing all that out. So we don't know what the record is. So I would ask this court in this particular case to say that they failed in their burden. But I also think that the court, when looking at unworkability, should not look at just the standard term of probation, 12 months or 18 months or whatever that is. I think it should look at what a reasonable amount of time would be. In this case, if the probation was expended for 2 years, that's $217 a month he'd have to pay. For 48 months, that's $100 a month. And as counsel said, for 60 months, $86. So is it unreasonable to extend probation for 5 years in lowering his payments down to $86 a month? And I also think there's something beyond that. I want to make sure the court understands our position on this. It's important that restitution be ordered even if it's never going to be paid as a part of probation. Because there is a statute that allows a victim to take that sentencing journal entry, go file it in the clerk in the civil division, and then the victim can then collect through civil process.
Is there any prohibition that of seeking full restitution? In this case, if they would have said a workable plan is $100 $100 a month for 12 months, leaving 4,000 short, would there be any prohibition for the victim to seek that other 4,000 through the civil process?
If
I mean, I know they can take it
Sure.
and get a judgment for the amount, but are they restricted to that in the damages they can seek through a civil action?
If I understand your question, if the court ordered $5,000 in restitution, but I'm only going to order you to pay $100 a month, they could take that sentencing journal entry and file it and collect
No,
it.
I'm going to say if the judge says, well, let's say the judge ordered $5,212.46, but the victim says, no, I had more damage than that. Can the victim seek additional damages, or is the victim limited in civil court to the amount of restitution awarded in criminal court?
I don't know of anything that would limit the victim because it's the state who's. I mean, the victim's really not a party to the action.
Precisely, and this isn't a civil collection action. This is a sentencing for a criminal offense.
Yes, I agree with that. But I do think there is a benefit to the victim to having an amount of restitution ordered, regardless of whether it's going to be paid as a condition of probation or not. A lot of these damages are small amounts, and if it's not ordered in the criminal case, you're just not going to see your victims going through small claims to collect this amount.
It saves the victim the aggravation of having to prove its actual damages in a lawsuit, correct?
That is correct. And so,
Counsel, can I ask a question?
Yes, ma'am.
Real quick? Kind of the bigger issue. You've already addressed in particular the poverty affidavit in this case, and that it would have been admissible for consideration in this restitution portion of the sentencing hearing. But just as a general matter, in terms of discharging the defendant's burden to demonstrate compelling circumstances to have an exception to the rule of restitution, does the defendant have to put on evidence that would be admissible under the rules of evidence, or how formal is the proceeding required to be?
well,
Because I have a feeling they happen informally all the time.
it happens informally all the time.
Yeah. Do you think that's a mistake? Do you think part of what we do in this case should be guidance on being more strict about what's admissible on this issue?
You know, this doesn't come up a lot. Usually there's a restitution memo put on. I guess the most of the dispute goes to what should the amount of, how much were the damages. So I don't know whether I want to say that the defendant has to have a formal hearing.
You don't have a provision of law that tells us it has to be a formal evidentiary hearing.
No, I would just the case law that says the defendant has a burden to put on evidence.
Right.
And in my view of what evidence is, statements to counsel is not evidence.
Okay.
And because if you don't make it a little strict, then you're left with situations like this where the poverty affidavit says one thing and the defense attorney's arguing something else. So I mean they do have a burden. So however they want to do it, but.
So, for example, if you have a situation as we did in the one case where the court just asks questions of the defendant and the defendant responds, is that adequate in your view to be evidence that goes to meet the defendant's burden?
I would think that would be, and I would say that would be adequate in my view because the defendant then is responding, and typically if the state had a question, the state could then ask the court to direct questions to the defendant.
And that's how it would have to happen rather than just swearing the defendant and letting the state examine the defendant as usual testimony is done?
I don't know if I don't know.
Okay.
I don't
All right.
know.
You're really not holding the defendant's feet to the fire on the rules of evidence. That's the bottom line of your position.
Right. I'm not going to be so technical to say that they have to be sworn, but it really needs to be more, I think in the Heron case, the defendant did respond to questions from the judge. In this case, there was none of this. It was really just two sentences by the defense attorney saying he's on disability and that only covers necessities. And that's not even borne out by the affidavit. So
I understand that this case is this particular
Right.
set of circumstances. I was really just trying to get a better picture of your position on the big
Sure. So I
issue.
know I would just ask this court to deny the defendant. And if you're gonna come up with a definition of what is unworkable, not limit it to the term of probation, but to a reasonable extension of probation. Any other questions?
I see none. Thank you, counsel.
Thank you.
Counsel, I don't have in my notes you reserved rebuttal time, did you?
I did reserve 2 minutes for
Is that
rebuttal.
right? All right, very well, thank you.
I just wanted to clarify what the statute actually says. The statute says that the defendant shall pay, or the court shall order the defendant to pay restitution unless the court finds compelling circumstances which would render a plan of restitution unworkable. And then later, at the end of that paragraph, it says if the court finds a plan of restitution unworkable, the court shall state on the record and detail the reasons.
So
thereof.
let me ask you something,
Yes.
Mr. Disney's last point. Should the workability of the plan be focused on the duration of the probation, or should it be unlimited? Should it be considered, let's say there's, in this case, $5,000 owed. Should it be on the ability to pay that off during the time of the probation, which is 12 months? Or should it be based on, I don't know, I guess 5 years is the maximum on something like this, or 4, I'm not certain under this category, but generally it's a little longer in terms of how long it can be extended. What should be the criteria here?
I think the primary focus for the restitution order should be what the defendant can pay within the amount of restitution, taking into consideration
In this case, during the 12-month period.
Correct.
What can he realistically pay of restitution, and not just the amount, and we'll extend it beyond?
Right. I don't think that the fact that restitution can be extended necessarily makes a restitution order workable, for the reasons Justice Johnson was pointing out, that it treats impoverished defendants significantly different than people who do have the $5,000 that they could pay it within that 12 months.
The flip side of that, though, is that if a person does the crime, they need to do the time, and maybe the period of probation for someone that causes considerable damage is longer because of the crime they committed rather than their poverty.
Well, I would argue that the way that the legislature has imposed severity levels to different types of crimes and different amounts of damage that are imposed. In this case, it was more than 1,000 but less than 25,000, so that was a severity level 9 crime, 12 months probation. If he had done more than that, it would have been a higher severity level, and that's what the legislature decided. So I think the primary focus on workability is what is reasonable for him to pay during that amount of probation. And unless there are further questions, I would ask this court to reverse the district court and the Court of Appeals.
Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Court will take this matter under advisement this time.